Well, yesterday we had the hearing on Karen Reed's motion to get reimbursed for the costs that she had to spend on her expert. So these were the costs, the over $12,000 that she had to spend to get her expert to travel to Massachusetts to spend the night, go to the Canton Police Department, find out that there's no video recoverable from the NVR. There's no logs to recover from the NVR. There's really nothing for the expert to do there. So she felt that that's not fair. Why should she have to spend over $12,000? So therefore, her attorneys filed this motion to recover those costs. Why should she have to spend this money for no reason? And we had the hearing yesterday. We went through the motion, and then we also did a recap video. If you haven't seen that, definitely go check that out. But then we had Judge Cannone's order and her opinion. So I want to go through the order and opinion because I think it has to be understood. And then I'm going to give you some of my final thoughts about this whole situation with this motion, with this hearing, and this eventual opinion and her order. So let me pull up the opinion. It's pretty short. We'll go through it, and then I'm going to give you some of my final thoughts. So here we have the decision and order on defendant's motion to recover expert-related expenses from the Commonwealth. After hearing and reviewing of the pleadings, the court credits the affidavit of Special Prosecutor Hank Brennan, paragraph 6. So Hank Brennan filed an affidavit as part of his response to the motion. And this is what he said in his affidavit, paragraph 6. Attorney Jackson expressed concern that the materials may no longer exist on the NVR, given the time that had passed since the event. I agreed with him and told him that I had no knowledge whether the materials still existed or were overwritten given the passage of time. So you see that there is some sort of understanding between Alan Jackson and Hank Brennan that it's very possible that this trip is going to be futile. It's going to be a wasted trip. So Alan Jackson knew that. So they knew that. So that is kind of where Judge Cannone is saying, look, if you guys knew this going in, so then you're taking the risk of spending all this money on an expert when you know it's quite possible that you won't have any sort of fruitful results. And this is what Judge Cannone continues. In light of the averment of ADA Brennan and in light of Attorney Jackson's acknowledgement during the hearing that he and ADA Brennan discussed his concerns regarding the likelihood of the video still existing, the motion to recover costs is denied. Okay, so basically she's relying on this understanding that Alan Jackson had with Hank Brennan, that they know it's possible they're not going to be able to recover anything. The motion to recover costs is denied. Further, though Attorney Jackson argued for sanctions for an alleged violation of Massachusetts Rule of Criminal Procedure 14, there is nothing in the written pleading raising this argument, and the issue is therefore not currently before the court. So, two things we have to unpack here. Number one, we discussed that when you're filing a motion, you have to give the judge authority why the judge can grant you what you're asking. But there's also another part, which is really part of that same idea. And that is that you have to specifically ask in your brief, in your motion, what you're looking for and why. So it's not just that you have to give the authority, but you also have to lay out the factual basis and specifically say in your motion that pursuant to this court rule, pursuant to this case law, that is why I am asking for this specific request. It has to be very clear what you're asking for in your motion. Okay, and like we spoke about, you can't just change it when you get to the oral argument. When you get to the oral argument from the judge, you say, judge, there's other reasons why I should get what I get, or I forgot to say that this is what I want in my motion, and therefore I'm just asking you now to give it to me. You can't do that. And the judge can very easily say, that's not how this works. You got to follow the procedure. You want something, you got to file a motion, specifically say what you want, and then tell me why you want that, and also lay out the factual allegations, and then also give me the authority to give you what you want, and then you can actually get what you want. So the way that this motion was written, and we've gone through this a few times, but the way that this motion was written is that Karen Reed should be able to recover her costs, to get reimbursed for her costs, because her expert was lured into coming down for no reason. Meaning this was some nefarious conduct. This was egregious conduct by the Commonwealth by pretending that there is something for the expert to do there, and there's something that the expert can recover there, when really there is nothing for the expert to recover. So that's essentially how the motion was written. And therefore, since that's the way the motion is written, the judge is going to concentrate on the conduct of the parties involved. That's what her focus is going to be. When you write the motion that way and you're saying they're doing something nefarious, they're not acting proper, and they lured us, they tricked us into getting this expert to come down there, and therefore we spent all this money, and therefore we want you to sanction Hank Brennan and the Commonwealth to pay for this expert. That is how they framed this argument. Okay, now, yes, I do know that in that motion, in that brief, they made some references to Rule 14 violations, and they did make some quote, they did cite to some authority like that, but that's not the way that the motion was written. The motion was written essentially in a way asking for the reimbursement of her costs because she was lured into this false understanding that there was something for the expert to do there. And that's how the motion was written. So once that's the way the motion is written, so then the oral argument is going to be limited essentially to that point. Now, of course, because this is a high profile case and because it's live streamed, there's going to be a lot more that we always see in all these hearings. There's a lot more talked about. There's a lot more argued about, but really that's the narrow focus of the motion. Did anybody do something nefarious here? Did anybody do something egregious? And then if they did, if the allegations hold up, then the judge may grant what you want. Now, again, there was also some lack of citation to authority that the judge could do this, but that's the way that this motion was being framed. And that's why the judge, in her opinion, is saying that because there was an understanding between Attorney Jackson, Alan Jackson, and Hank Brennan, they both acknowledged it. They acknowledged it in oral argument. They acknowledged it on the record that they were not 100% sure whether there's going to be anything to recover. Then you can't argue that you were lured into this false understanding, false impression that there's absolutely something for the expert to do there, and then you spent all this money on the expert. You knew already before that there's a possibility that there's nothing for the expert to do there. So if you know that and you spent the money, we're not going to require the Commonwealth to reimburse you for those costs. So that's the way the motion was drafted. Now, during the hearing, what Judge Cannone is saying here is that Alan Jackson asked for Rule 14 sanctions. Now, Rule 14 sanctions is a different motion. It's a different issue, right? That's a little bit of a different issue. And also, it has to be spoken about in the motion. You should say, pursuant to Rule Criminal Procedure 14, therefore, we are asking for these sanctions. And Judge, you can give these sanctions. You can give these monetary sanctions because of a specific case. But because this was not addressed and directly asked for in the motion, the judge is not going to entertain it during oral argument. And that's exactly what she is saying here. She's saying that even though you argued for this during the oral argument, but since there's nothing in the written pleadings, meaning this written brief that you wrote, the motion, therefore I'm not going to consider that this is an issue in front of the court. Okay, so this really comes back to what I was saying yesterday, and I put out a tweet about this. And the idea is that if you look at this motion, something that I mentioned right away as soon as I saw that motion, I let you all know way before the hearing. I let you know that this was something that was odd to me. And I've seen a lot of the filings in this case. And generally speaking, the filings are done very well. And it's well researched. It's asking directly for what you want in that specific motion. It's the writing here is done very well. And these are very good attorneys. There was something off about this motion. And that's why I put out a tweet saying, I'm not trying to create a conspiracy here, but there's definitely something up with that last motion. I don't know who wrote it. I don't know who reviewed it. I don't know how it was filed. I don't know much about it. Maybe they wanted to add more to it. But the reason that I said that is that it wasn't really the same type of motion that I've seen in this case throughout covering this case. There was something off about it. And specifically, even though there were some citations to authority, but it wasn't the citations of authority that we need in this case. You're asking for monetary sanctions, then you have to cite a case that requires or that shows that a judge could impose monetary sanctions. And that's why, as soon as the hearing was started, Alan Jackson right away quoted to a case which allows the court to grant monetary sanctions, because that was not in his brief. That was not in the motion. So that's why right away he mentioned a case. He had to cite some authority that the judge does have the ability to award monetary sanctions. But that was not in the brief, as I've spoken about a lot of times already. So if it's not in the brief, it's going to be much harder to argue during oral argument. And then on top of that, it was not clear in the brief that you're seeking Rule 14 sanctions. Rule 14 sanctions, and here, if you're seeking Rule 14 sanctions, then the argument is not going to be that Hank Brennan led you down this path of thinking that there's something there that there's not, that wouldn't your argument would not be limited to that. Your argument for a Rule 14 violation could still be the fact that the Commonwealth did not preserve or properly preserve these videos. And because they didn't properly preserve the videos, and therefore you still are willing to take the risk to get an expert there. And once the expert's there, the expert can tell us that they did not properly preserve these videos. Then there can be an argument for a Rule 14 or Brady violation, and therefore there should be some sanction associated with that. But because that was not the focus of the motion, because they didn't put that in their pleadings, so then they cannot come to the court now and ask for that. But this is the good news for all of you Karen readers, free Karen readers. The good news is that you can still bring this up in another motion. In the next motion that they're going to be filing, they're going to be filing a Brady motion pretty soon, a Rule 14/Brady motion violation. They are going to be filing that motion to dismiss. There's going to be other sanctions available. So they could definitely, in the next motion that they're arguing, now they're going to want to argue to dismiss the case. But another part of that motion that they could put in there is that if Your Honor is not willing to grant the dismissal of this case, well, then still we are asking to get reimbursed certain costs. So this has the next motion, the motion to dismiss, is going to be on Brady violations and Rule 14 violations. So those sanctions, they range. They can be monetary sanctions, and they can also range to dismissal, flat out dismissal. So the good news is for you is that they can still file this motion for sanctions, for monetary sanctions. They're not barred just because of this motion that they file now. It's not like you already litigated this issue and you can't bring it up again. There's none of that because this wasn't properly in front of the court. So you could now properly bring it in front of the court. Okay, so that could be what happened. Now, some people think that this was done purposely, that they filed this motion purposely because they wanted to bring these issues up already in front of the court. I don't buy that so much. Okay, if you wanted to bring these issues up in front of the court, you're going to very soon in this next motion to dismiss. You can do it properly. You don't have to do it in this way where you kind of look a little bit silly here. So I don't think that this was all some sort of major strategy or ploy. I think this was a mistake. I think there was somebody dropped the ball a little bit here. And it can happen. You know, you're involved in a very high-profile case. There's a lot of things going on. And most likely, this is not the only case that these attorneys are dealing with. And they have to delegate some of the tasks to some other attorneys. So, and you could be a little bit, not as careful to review everything and make sure that everything is there that's supposed to be there. So it's just possible. I just think that there was probably some sort of mistake here with this motion. It wasn't done properly. I pointed it out to you guys right away. We talked about it during the hearing. That's why Alan Jackson tried to fix it right away with his oral argument. He tried to bring up that case, which he didn't cite to in his motion, in his brief. And then he tried to also argue for Rule 14 violations, even though that does not appear in the motion. I just quite simply think that this was a mistake. This was just a simple mistake. Mistakes happen, okay? When you have a lot of cases, this is just, no one can be perfect. So that's all. That's what I think happened. And again, it's not such a crucial mistake because they will be able to file this motion again. Not this motion, but file a motion, a Brady motion, a Rule 14 violation motion, and then they will be able to ask for whatever type of sanctions they want. And then show the case law that says you are allowed to ask for those sanctions. Because that direct quote that Alan Jackson quoted when he started off his oral argument, that was actually monetary sanctions pursuant to Rule 14 violation. Okay, so again, even though he cited it, it really didn't really tie back into his motion. So don't worry, I assure you that in the next motion to dismiss and for other sanctions or alternatively other sanctions, this will definitely be included. I mean, it could be included. And, maybe he's not going to want to give this alternative to the judge. Maybe the judge is going to, but it could be brought up again. Okay, that's the point. So that is what my feelings are about this motion. That's my take on it and on this order. So that's going to be it for now. We're still looking forward to this next motion to dismiss that's going to be filed by, I think it was February 20th. And we'll see what else happens up until that point. But that's going to be it for now. Thank you all for joining. Thanks for all for watching. If you haven't yet, please subscribe, like, and we will see you next time.